Welcome to another episode of the Lawyer Society Legal Podcast. This episode will be covering an interesting interpretation in custodial matters where the husband and wife, that is the father and mother, are going for the custody of their child. Here we have three different laws that will be discussed today. One is the Guardians and Wards Act of 1890. The next is the Hindu Marriage Act of 1955. The third law is the Hindu Minority and Guardianship Act of 1956. Now, if you see the Guardians and Wards Act, as per the Guardians and Wards Act, Section 3, the Guardians and Wards Act shall be read subject to every enactment heretofore or hereafter passed relating to any court of wards by any competent legislature, authority or person in any state to which this act extends. And nothing in this act shall be construed to affect or in any way derogate from the jurisdiction or authority of any court of wards or to take away any power possessed by any high court. So as you can see from the year of this particular act, it is a law which came before the Hindu Minority and Guardianship Act of 1956 and also the Hindu Marriage Act of 1955. So when you read Section 3 of this particular Act of 1890, you know that this act cannot be ignored when you are considering the provisions regarding custody coming under the subsequent laws, which is the Hindu Marriage Act and the Hindu Minority and Guardianship Act as per this video's concept. Likewise, when you read Section 2 of the Hindu Minority and Guardianship Act of 1956, it says the provisions of this act shall be read in addition to and not save as hereinafter expressly provided in derogation of the Guardianship and Wards Act 1890. So it is read in addition to. So generally, let's not confuse ourselves. When we consider these two laws, we know that they have to be read harmoniously, except when the Act of 1956 says that you cannot read them harmoniously, and that has to be said expressly. Now let us come back to Section 7 of the Act of 1890. Section 7, as you can see, it provides for the power of the court to make order as to guardianship. If you simply read, it is about declaring a person to be, so if you see, this actually provides the court with the power to declare a person as a guardian. Now let us read Section 25 of the Act of 1890. This provides for the power of the court to order that the ward must be brought to the custody of the guardian. So if the ward leaves or is being removed from the custody of the guardian, then he can be brought to the custody of such a guardian using Section 25 of this Act. So Section 7 is about declaring, getting yourself declared as a guardian. Section 25 is about the custody where the petitioner is already a guardian. So this is the subtle difference between Section 7 and Section 25. Now let us move on to the Act of 1956. As per Section 6 of the Act of 1956, it reads, the natural guardians of a Hindu minor in respect of a minor's person as well as in respect of the minor's property, excluding his or her undivided interest in the joint family property, are, in the case of a boy or an unmarried girl, the father, and after him the mother, provided that the custody of a minor who has not completed the age of 5 years shall ordinarily be with the mother. So this is the particular clause that we'll be focusing in this video, because we are looking at the case of a boy or an unmarried girl. So this is when the boy is aged below 18 or the girl is unmarried. The natural guardian is the father and the custody shall be with the father if they are aged above 5 years. But if they are below 5 years, although the father is the natural guardian, the mother is to have the custody. So that is the interpretation of Section 6 Clause A. Now what do you mean by the words after him? This was interpreted by the Honorable Supreme Court in the case of Miss Geeta Hariharan versus Reserve Bank of India, reported in AIR 1999 AC 1149. In this particular case, it was said that the words after him must be interpreted to mean that it signifies the absence of the father, be it temporary or otherwise, or total apathy of the father towards the child, or even inability of the father by reason of ailment or otherwise to take care of the children, that is. So it doesn't mean that after him must necessarily be interpreted to mean that the father must have died in order for the mother to be the natural guardian. So even if the father is not able to take care of the child because of some illness or he is not taking care because of his own apathy, then in such cases the mother is the natural guardian. Now let us look at section 13 of the Act of 1956. Section 13 of this Act reads, in the appointment of declaration of any person as guardian of a Hindu minor by the court, the welfare of the minor shall be of paramount consideration. So this is the most important provision, because it says that even if a person is a natural guardian, even if a person is entitled to custody at that time, if the interest of the minor is not served by such person having custody of the child, then the court will not make such a declaration or will not return the child to such a parent. When we attempt to read section 6 clause A of the Act of 1956 with sections 7 and section 25 of the Guardians and Wards Act of 1890, while also factoring in section 13 of the Hindu Minority and Guardianship Act of 1956, we can generally arrive at a finding which can be summarized as the following. So the first point to be understood here is that when a father is still the natural guardian, keeping in mind the interpretation for section 6 clause A of the Hindu Minority and Guardianship Act made by the Honorable Supreme Court in the case discussed earlier, which is the Geeta Hariharan case, the mother can make an application under section 7 of the Act of 1890 read with section 13 of the Act of 1956 for appointing her as the guardian. This is because as per section 6A, the father is the natural guardian, but if the mother wants to be declared as the natural guardian, then she has to apply by section 7 of the GWA, and she has to bring in the welfare of the child here. So she has to use section 13 of the Act of 1956. So when you read these provisions together, the mother has a remedy there. The second point that we must be looking at is when the child is below 5 years, the custody must ordinarily be with the mother. This is as per section 6 clause A of the Act of 1956. Hence, in such a case, the mother may make an application under section 25 of the Act of 1890 read with proviso to section 6 clause A of the Act of 1956. Now she doesn't have to invoke section 13, that is the welfare of the child, because as per the proviso she is entitled to the custody of the child when the child is below 5 years old. So she is using section 25, that is returning the ward to her custody when the ward is being removed from her custody. So you have to read section 25 along with 6A. This is because the two acts must be read harmoniously because of the sections we have already discussed, both under the Act of 1890 and the Act of 1956. The third point to be discussed here is when the father is still the natural guardian and the minor child below 5 years old has been removed from his custody by the mother, the father has to move an application under section 7, which is declaring him as the guardian, read with section 6A of the Act of 1956, again read with section 13 of the Act of 1956, because when the child is below 5 years old, the mother is entitled to the custody, but considering the welfare of the child, which is section 13, the father is making an application under section 7 using it along with section 6A, because you have to read all these provisions together in order to understand and come to the conclusion that the father is the natural guardian at that time, and in the welfare of the child, the father be declared as a natural guardian and the custody be given to him. The next one is when the father is still the natural guardian and the minor child above 5 years old is removed from his custody by the mother. He has to move an application under section 25, that is returning the child to his custody, read with section 6A of the Act of 1956. Because when the child is above 5 years old, the mother is not to have the custody ordinarily. So now the father can use section 25 read with section 6A. He doesn't have to invoke section 13. Whatever has been discussed earlier in this particular episode has been to some extent observed by the Madras High Court in the case of Vadivel versus Uma Maheshwari, reported in 2014, 5 Madras Law Journal 150. Equivalent citations are 2014 4 CTC 450, CDJ 2014 Madras High Court 2588. If you see from paragraph 53 of the judgment, very similar observations have been made by a single judge of the Madras High Court. So you can refer to this judgment if in case you have any further doubts regarding which sections you can read together and apply before the court for the custody of the child or for getting your party declared as the natural guardian as per the two acts. In the part 2 to this video or to this episode, I will be discussing how the Hindu Marriage Act of 1955 must also be considered when you consider the issue of custody matters between the father and mother of a child. And I assure you that part 2 will be even more interesting because there is one amazing interpretation of a particular provision from the Hindu Marriage Act, which we will be discussing in part 2. I'll be sharing this episode both on Spotify and YouTube, so please do check this video on YouTube if you're listening to this on Spotify, because on YouTube I will be giving pictorial representation, that is visual representation with the provisions and all that, so that you can read as and when you listen to it. And if you like this particular episode, do give a like, do give a thumbs up, and share this with your legal groups, your law friends, your colleagues, your seniors or juniors, so that everybody is well informed. Thank you. Until next time.